Hey, aloha everyone. My name is Todd Yukutake. I'm with the Hawaii Firearms Coalition. Today we're hosting a webinar to go over Hawaii's self-defense laws and HB 534, which is a bill currently in the legislature concerning use of force and self-protection. And before we get started, just want to go over some disclaimers real quick. So this is for educational purposes only. This is not legal advice. Please consult with an attorney. This is an overview of Hawaii's complex self-defense laws. HB 534 will undergo changes as it moves through the legislature. So what's relevant right now may change in the future. And self-defense has many variables and situations. Please seek additional training. One good course to attend is this active self-protection, winning the fight after the fight. This was a few days ago, but if you register for this, you can get a recording of it. And they have a part 2 next month. It's free. And they're going over what happens after a self-defense incident. You know, might get arrested, the legal process you have to go through, civil lawsuits, things like that. So it's a good 2 hours well worth your time. And these are the references for tonight. I'll put this in the chat. There's HB 534, which is again the bill in the legislature. You can read the actual wording on this website. Current self-defense laws, that's called Hawaii Revised Statutes, Chapter 703. And there's many sections on it, so you can go through those on your own. And again, active self-protection. They're mainly a YouTube channel. They what do you call it? They review self-defense incident real-life videos. I think they have probably a couple of thousand on there. Very good watching. And they have an extra channel which goes over other stuff like legalities of using self-defense. But we do have some special panelists today. We have Michael J. Kitchens with Stolen Stuff Hawaii, Megan Cowell with the Law Office of Megan Cowell, and Andrew Namiki Roberts with the Hawaii Firearms Coalition. And let's do some brief intros. Michael, if you could go over your background real quick.
Got you. All right. Hey, hello, everybody. I'm Michael Kitchens. I'm with Stolen Stuff Hawaii. I'm the admin and creator. Stolen Stuff Hawaii has been around since 2014. And our primary mission is to support those who've been victimized by crime. So thank you for your time, Todd, and the rest. Thank you.
Okay, Megan, you want to introduce yourself?
Aloha, everybody. Hi, my name is Megan Cowell. I am a civil and criminal defense attorney. I was a prosecuting attorney for about 5 years, and then I started practicing in civil law, and now I run a practice primarily prosecuting plaintiff's case and defending big, high publicity criminal defense cases.
All right, thank you very much. Thank you for being here. And the reason we put this webinar together is most people don't know what to do in a self-defense situation. You know, it happens all of a sudden in an instant, and you don't really have time to think about it when, you know, a criminal is attacking you. Much less after it happens too. There's a lot of things that happens after. If you were to injure the criminal, you might get arrested. Might have to go to trial, spend hundreds of thousands in legal fees, and even lawsuits too. Certainly lawsuits nowadays. So that's why it's important to stay up to date on these things. But yeah, let's get started with our panel discussion. Michael.
Yeah, so I guess I'll kick it off by just describing the current situation that we're in. You know, I've ran SSH since 2014, and during that time, I've witnessed an incredible amount of crimes. I've managed the group full time, basically for over 6 years, and combined with the recent effects of the pandemic, we've started to see crime escalate. And it's been utterly demoralizing to our general public, the community itself, our law enforcement, and even the people in our judicial system. So it's essentially it's nailed down the idea that you know, our crime is basically dependent on a revolving door of failing judicial of a failing judicial system, really. And the one thing that I've seen with the majority of the crime that happens is that we're at a complete disadvantage as the community. You know, the laws, the regulations, everything that happens seems to be geared towards defense of the criminal's rights. And it provides an opportunity for the criminal to flourish. You know, as far as we're concerned, we're obligated to retreat. We're obligated to give our stuff away, you know, when we're threatened. We're basically obligated to accept the crime that's being committed against us. And we're even prohibited the actual tools that are out there for us. I mean, we only get to use pepper spray in our self-defense. You know, there's really not much for us to go off as a community to protect us. You know, and when it comes to criminals, when you are a member of a group like SSH, you see victims reporting the crimes every single day. You see them not from the news and not from HPD or, you know, some, you know, official source. You're seeing the crimes explained to the group from the victim itself. And that's very powerful. And it shows a side there that you won't see in statistics. You don't see the trauma when you read a news report. You know, when you're hearing it directly from the source, you can ask the questions of that person and you can see what's happening. So basically, you know, it's just shown that with this pandemic happening, we've seen an increase in SSH of crime. You know, really what it's done is it's allowed the criminals to just crank it up to 11. You know, and you know, they consistently prey on targets of opportunity, no matter where they are. You know, it could be just walking down the street. You know, there's an opportunity to get assaulted. You know, we've seen our elderly, for example, have been extremely popular targets for these criminals. You know, just coming out of nowhere and stealing their purses. You know, killing some. You know, unintentionally or intentionally. You know, it doesn't really matter. You know, and we've seen this steady progression on the SSH. So. In regards to this bill, I think it's a remarkable bill because it's basically all about self-defense. It's not about guns. It's not about a specific weapon or tool. It's about the public's right to defend themselves no matter what the situation is. If it's a crime against you, your family, you know, in your home, in your dwelling, you know, or even at your workplace, or even being out in the street, you have a right to defend yourself, your family, your property. I think that it's been reworded, you know, thanks to the efforts of everybody that testified, as well as the Hawaii Firearms Coalition. You know, you guys did a good job in basically taking that bill that first came out, gutting it, replacing it with the contents of a more appropriate bill. And what we've ended up with is a bill that just basically is about the right to self-defense for everybody in the community. You know, every single one of us has a right to defend themselves from crime. And that's something that we don't currently have here. And that's the reason why I'm even more attracted to this bill, and I support it immensely. You know, it's an all across the board defend yourself bill. And I think it's something that really we as a community need to get behind. We need to show our support. It doesn't take a lot of effort to do this. So I really think that this is the way to go, you know. And I really wanted to take this opportunity to join this panel because I want to stress to my members that, hey, you should take a look at this bill, and if you support it, you should take a moment to take 5 minutes and send in testimony. So thank you.
All right, thank you very much. Panelists, anything to add on to that real quick? All right, we'll move on to the current current self-defense laws with Megan Cowell.
Thanks, Todd. So if you don't remember anything at all about the law, you should remember two things. Number one, it must be immediately necessary. And number two, it must be equal force. So necessary and equal, that is the status of the current law. So you are able to defend yourself as long as it is immediately necessary and equal force. What that means is, well, I won't get into an example, but what that means is that you are judged based on the facts and circumstances as you objectively believe them to be in the circumstance you're in at the time you use the force. And so the jury will have to put itself in your position at the time that you used the force and decide whether under those circumstances the force that you used was either number one, immediately necessary, and 2, of equal force. So I will also say that you don't have the duty to retreat from your home or your place of work. And I think that a lot of people get that confused. A lot of people refer to it as stand your ground or the castle doctrine, whatever you want to call it. In Hawaii, you don't have to retreat in your home and at your place of work. There are exceptions for the place at work, but those don't generally apply. I can answer questions about that if people are specifically interested in those exclusions. But again, you don't have to retreat in your home or at your place of work. I will talk about, I know this is generally self-defense and not necessarily deadly force, but I will say that deadly force requires the threat of serious bodily injury, death, rape, sodomy, kidnapping. And so even if you're in your home, and I think this is probably where people get a little concerned, is that even in your home, if you're not faced with serious bodily injury, death, rape, sodomy, or kidnapping, you actually can't use deadly force to protect yourself. So for example, the person out in Eva, there was someone breaking into his home. He was in the wrong home and he was right at the door and the homeowner shot him. I imagine, I don't have anything to do with that case, but I imagine the reason why he was charged is because there was no evidence of serious bodily injury, death, rape, sodomy, kidnapping, etc. So he was charged. That's an example. Another example, which I am not a part of, and I never read the police reports, but I know what I heard from the news is the man in Kalihi who shot one of the several kids that had been shooting at him with a BB gun and coming to his home multiple times, even after he called 911. The homeowner, shot one of the kids I believe it was in the back, and he got charged as well. I don't know what the status of each of those cases are, but they are examples where people have used deadly force to protect themselves and have been arrested and charged. And, like Todd said, you do end up spending, if you're going to hire a private attorney, you're looking at about $100,000 to defend yourself. Then if you're sued, assuming that your homeowner's insurance policy doesn't kick in, you're looking at about $250,000 to represent yourself in the civil case. So it gets expensive, and these types of cases drag out for a very long time just because they're so complicated. So that's generally self-defense. I'm happy to answer any specific questions.
Okay, Megan, I do have a couple of questions here from the audience. Taylor says, do I have a legal obligation to de-escalate or a moral obligation? Well, I guess moral, yes, but legal?
Well, so legally, if you're in your home or at your place of work, you don't have a duty to retreat at all. I heard you use the term de-escalate, but it depends on what you mean by de-escalate. You have a duty to use the force that is being used against you. So, if someone is, it's so difficult to give examples, but if someone doesn't have a weapon and is punching you in the stomach and punches you, let's say 5 times in the stomach, you can't take out a knife and stab the person in the back 25 times. Okay, because that is a difference in the type of force that's being used. If someone is punching you in the stomach, do you have a duty to de-escalate, like push the person away, kick the person away? I call that self-defense. I don't know how to better explain that. If you kick the person in the head and you push the person away, it's self-defense. Again, if you're in your home or at your place of work, you don't have the duty to retreat. I'm not sure if that answered the question.
Yeah, and I guess it's situation dependent too, right? If like elder elderly person is being punched in the stomach and they can't fight back, maybe a knife might be reasonable in that case.
These are issues for a jury to determine. A deputy prosecuting attorney is going to look at the case and determine if it was equal force. And if the deputy prosecuting attorney does not believe that it was equal force, but instead that it was the defendant was the first aggressor, the deputy is going to charge the case. Then it will be up to 12 people to decide whether or not the force was immediately necessary and equal. And so you're depending on these 12 people to make that factual determination. And yes, as Todd said, every case, whether it's self-defense or something other, is always based on a case-by-case basis. The facts are always very determinative in deciding whether to charge or not charge.
Oh, okay, thank you.
Can I ask Megan a question too, Todd?
Oh, go ahead.
Megan, so in regards to this bill that's now before us, HB534, how does it differ now compared to what's already in the books?
Sorry, I haven't looked at that bill. I'm so sorry, Mike. I wasn't involved in that part. And this was kind of last minute, so I just looked up. I just looked what the status of the law is now. I'm happy to go over it with people after I read it.
This is a good time to move on to our next subject. If you're finished, Megan, Andrew's going to go over exactly what's in HB 534.
Okay, so HB 534, when it was initially introduced to the legislators, was actually the opposite of what it does now. It was introduced and it actually removed some of the protections we currently have. What it actually did was remove workplace as a place that you don't have to retreat from. And that was essentially the only part of the bill that was in there. The rest of it was just language changes that made the language of the bill more inclusive. It was less gender specific, and it just made it a more inclusive language wise, but it only removed the ability to use force within the workplace. So when it first came up for hearing, we put out a call to action to our members and to members of the public to change the wording to match another bill, which had a similar subject. And what that bill did was it changed it into, and I'm going to use the term stand your ground. It's not a term I like to use. It makes the bill very, very, very confusing. It gets mixed up with other states that have other stand your ground bills that have different language. This bill is tailored to Hawaii's current law, and it just clarifies. It clarifies what you can and can't do. So the current bill as it's written, I believe is like 6 or 7 paragraphs of text. This brings it down to, I believe, 3. So the wording of the bill that's come up now will allow a person to use force to defend themselves, to defend their property, and to defend others without a duty to retreat. What that means is if you feel that there is a threat to your safety, you can use an appropriate amount of force to make that threat stop. So the threat still, the force used still has to be proportionate to the crime. So if somebody comes up to your vehicle and you're sitting in your car and they start banging on the window, can you pull out a knife and stab them? No, that's not proportionate. What you could do is push them away and leave the area. Now, if they break the window, obviously that's a forced entry to your vehicle, and one would believe that if they're willing to break a piece of glass to get to you, then a greater level of force may be necessary. At that point, pepper spray, hitting them with a walking stick that you have, if you're an elderly person or something like that, might be more proportionate. If they're armed, for example, with a knife, and I know there's been some confusion with this, if somebody's got a knife, you have to use a knife to fight them, sort of comments that came up in the past. And I'm just going to clarify that. A knife is deadly force. At that point, you're allowed to use deadly force to counter that. So if somebody has a knife and they're threatening to use that, you don't have to run to your kitchen and grab a knife if you already have a gun. It's a proportionate force. It's an equal force. So the bill clarifies that you can use force to defend yourself as long as you believe it's immediately necessary. That kind of goes back to the de-escalation thing. If you have an opportunity to de-escalate a situation or walk away from a situation, do you have to use it? The way this law is written, no. It says that you don't have to retreat. Should you use it? Can you afford to pay the lawyer to defend you? That's the question that comes up there is, you know, just to get a lawyer to speak to on a case like this, as it's been said, you're looking at $25,000 coming out of your pocket right away, and you know, $100,000 to $200,000 coming out of your pocket to take it to court and go to trial. The second most important part of this change in the bill, and I'm just going to read it as it's written. An actor who uses force, including deadly force, as justified and permitted under subsections 1 and 2, is immune from criminal prosecution and civil action for the use of force, unless the force was determined to be unlawful. This is probably the most important part of this bill that needs to be passed into law. What this means is that when you go before a judge and the judge says, you're not guilty or the force was justified, you cannot be sued in civil court. An example of that would be is if somebody pushes you and you fall down and you pull out pepper spray and you spray them in the eyes, justified force. But if you injure them beyond that, say for example, they have an allergy to it and it causes damage to their eyes or something like that, they could bring a civil claim against you. Now, if the initial force is legally justified, that civil case would get thrown out. They wouldn't be able to sue you. In a deadly force situation, if somebody breaks into your home and you confront them in your living room and they pull a knife and you shoot them, or you get into an argument with them, they get stabbed, it means that their family couldn't bring a civil case against you for their death. That's what that part of the law is about protecting. It's about protecting the victim. It's a victim's rights law. It's about protecting the victim from criminal and civil prosecution should force be used. Deadly force in this still has to be justified. A lot of people have brought up the case out of Florida with Trayvon Martin. If you instigate a situation where deadly force comes up, that is not justified under this law. Florida's law is written very, very, very differently. Hawaii's law is very, very clear. You cannot instigate the situation that leads to deadly force. You cannot be committing a criminal act. If you're dealing drugs and somebody tries to rob you as a drug dealer and you shoot them, that is not justified force. You were committing a crime whilst you used it. That's still illegal. If you're harassing a person and they push you and you pull out a knife and stab them, that is not justified force. You are harassing them. That is a crime. You're committing a crime, and therefore force of any kind would not be legally justified. This is for situations where people are in their own property, people are at work, people are in their car driving to work, and a situation happens where they're being attacked or becoming the victim of a criminal. And that's the important thing to note. This is very, very different to other states' stand your ground laws. Hawaii is making sure that you can protect yourself if you're the victim, but not if you instigate the situation.
I have a comment about that, a portion of that. I'm a little concerned about the fact that if you're found not guilty in a criminal case, that the person can't bring a civil suit against you. I'm not sure if that's going to be strong enough to pass because of the different burdens of proof. In a criminal case, the government has the burden to prove beyond a reasonable doubt that you're guilty. In a civil case, it's much less. It's preponderance of the evidence, which means more likely than not, typically translated to be 51% versus 49%. So I am a little concerned about how that's written. If in fact a jury in a criminal matter finds you not guilty, that doesn't necessarily preclude you from the victim from bringing a civil suit against the defendant. I'm not sure how they're going to reconcile that difference in standards, but it concerns me.
It could be where they just end up striking the civil action portion from the actual bill and just leave it as from criminal prosecution. That would make it okay, wouldn't it?
Well, then it makes that language duplicative because it doesn't save you from criminal prosecution. You have to be found not guilty. and you've already been prosecuted. So that's the process, right?
The wording under the law says an actor who uses force, including deadly force, as justified and permitted under this section. So I guess you have to be found not guilty, not because there's no evidence, but they have to explicitly say it was justified force under this section, rather than there's not enough evidence to say that you killed them. I know other states have very similar wording to this in their civil protection laws as well. I believe Florida also has this. And I'm keep bringing up Florida because it's a state that I'm familiar with what their law says.
Well, if somebody is going to be advocating for this law, I would be prepared to answer questions about the jury instructions, because as it stands right now, we don't ever ask the jury why they found guilty or not guilty. So if that's the case, the jury instructions will have to have a special verdict form, which specifically states that they're unanimous in the not guilty verdict because of the use of force. And then, and only then, can the person be saved from civil prosecution.
Actually, there is a similar law to this, kind of like a companion bill in the Senate, which hasn't been heard yet, HB534. Basically, it's a little similar in that if you go through a trial, the court has, and you're found not guilty due to self-defense, the juries and I think the judge or the jury is going to have to answer some questions about the case. And with that, if everything's passes, then the person's legal fees will be covered by the state. And they're protected from civil liability too. So it's HB534. So maybe something like that might work with this bill too. And it is going to the Judiciary Committee on Tuesday. So they'll probably be looking at amendments to the bill to address what you just stated.
I think one of the primary opponents of the bill, though, now just thinking about it, is the fact that, civil action, we should be allowed to defend ourselves if it's appropriate use and it's appropriate defense using the proper level of use of force and everything like that, and we do it correctly. The feeling is, I think, in general with most people, is the fact that we should not be held liable for taking that action against somebody who's trying to commit a crime against our person. How does that work? I mean, that's a civil right for them to sue me because I protect myself from them trying to rob me?
I mean, yeah,
Sorry.
Yeah, I totally agree with you, Mike. I mean, I am, a female, young, I walk down the street. I have the right to protect myself. I'm a gun owner. And if I believe that it is immediately necessary to use deadly force, I would like to be able to use deadly force without being sued, because that is my right. Right now, as the law stands, that's not true. Let's say someone breaks into my house and I shoot them. Number one, I can be charged for murder in the second degree. But number two, even if I'm not charged with murder in the second degree, if the family knows, that I may have assets and that they could get a payout, they can sue me for shooting that person, despite what happens criminally, whether I'm charged or not charged or found guilty or not guilty. They can still sue me. So, that's why this bill is very important, because people do have the right to use self-defense, whether it's lower level or higher level, and we should not be penalized for that. That's why people should be paying attention to this. And I'll say I haven't, but I'm happy to. Yeah, it's important.
Okay. Yeah, it was after I said strike it from it, I started thinking about what you guys were saying and realizing, well, actually, this is a very important part of the bill, and that without it, it actually makes this a very weak version of a bill, so yeah.
I agree. But so that's why I'm saying that whoever's advocating for the bill is going to have to be prepared to answer those questions regarding the specific findings of the fact finder, whether it's judge or jury, and whether there's going to be a special verdict form, because as our practice right now does not include those things.
All right. So, yeah, again, if anyone has any comments on this bill, you can actually submit testimony to a legislature. There is a hearing on Tuesday at 2 o'clock in the judiciary. You can create suggestions maybe about the civil liability. They're going to go through that and vote to pass this bill or not in this committee, and if there's going to be any changes added to it. Yeah. Okay, just had one comment from Dan Gu. I guess this is going back to Taylor's question about de-escalation. He just brings up that stopping force, or I guess stopping your defensive force when the person is subdued or not attacking you, that could be considered de-escalation. Let's see. Actually, I just had just wanted to bring up try and bring up a couple of examples for this bill. I'm not sure if these would be covered by this bill or not, but let's say if you're a store owner. I know I've heard this before in the news, but someone steals a pack of gum and they run out the store, and store owner shoots them. Would that be covered under this bill?
No, not at all. This is Hawaii splits its self-defense laws up into multiple sections. So this would be with regards to defending yourself and defending yourself within your property. So within your home or within your vehicle. Defense of property is covered under a different section of the HRS. And it's a very in-depth set of rules and set of guidelines of the amount of force that you can use to defend property. The only time you can use deadly force to defend property would be if the person trying to take the property is threatening deadly force against you. It's a very narrow window. Essentially, it's the same as deadly force against the person. You still have to show that the person taking the property or attempting to take property is threatening serious bodily harm or death. And for Hawaii, just for those that don't know, serious bodily harm means permanent injury or making your insides your outsides. That's the simplified version of it.
Yeah. How about a similar situation? Let's say they steal a pack of gum, they start running out, but you grab them by the arm and they start beating you in the head, or they pull out a knife. What can you do then that would be covered under this? Would that still be a property issue, or would that turn into a crime of violence under this bill?
The way Hawaii's current laws are written, you would not be allowed to, you would have to surrender the property to them and let them. Hawaii's deadly force laws are very confusing as they're written right now. The law implies that if somebody is trying to take property from you and you have the opportunity to let them go without using deadly force, you must do so. So if somebody's stealing your wallet and you can let them have your wallet and leave with it without causing them death or using deadly force, you must follow that path. And that's the way the law is written, and that's how the law is carried out. And I'm sure Megan will know more about the current way the law is currently implemented than I do. But that's the common understanding of what the law says.
Yeah, I mean, Andrew is absolutely correct. You cannot use force. You have to let the person go. But then it becomes a question of, are you using force to defend yourself? Again, it's so factually specific, right? So, you know, if it's me, a 40-something-year-old female that owns the store, and I have a gun, you know, under my desk, and they're stealing a pack of gum. It's a 6'2" male stealing a pack of gum, and I try to grab him, and I try to stop him. At that point in time, I cannot use my gun to shoot him. But if he turns around and starts beating me, you know, punching me in the head, kicking me, and now I'm facing serious bodily injury, lacerations or broken bones, it it turns into self-defense instead of letting him go with the pack of gum, or it'll depend on how the deputy prosecutor looks at it, quite frankly. If it becomes, I believe I need to use serious bodily injury or death to protect myself because he's broken my bone or lacerated my skin or face, now I can use the gun. I'm using serious bodily injury or death to protect myself against serious bodily injury or death. So it's very fact specific. It depends how everything plays out, but definitely not to just steal property. You cannot use deadly force for that.
I do have one more example, and I want to bring this one up just because this happened in the last week. Let me start this video. So this happened this week. This was in Kailua, and it's 3 o'clock in the morning, and the person's home, their Ring doorbell goes off, and this gentleman is pushing the bell. You can see in his hand right there, you do this right here. That's a machete. So the guy's come up to the door with a machete in his hand and pushed the doorbell. And he pushes the doorbell and walks away. Now, we don't know the rest of the story, what happened, where he went, why he was pushing the doorbell, what that whole entire situation was. But this is a real situation that's been happening in Hawaii, where people come up to the door, they push the doorbell. When the door's opened, they push the door through, they tie up homeowners. Often they're armed either with a knife or a firearm. That situation right there is what this bill is meant to fix. The way Hawaii's current law is written, if somebody comes up to your door and they've got a knife like that, they're outside of your home. What you're supposed to do is walk away from the door, pick up your phone, dial 911. You can't defend the outside of your property. Even if he's pounding on the door, trying to bang through the door to get into the building, until he's actually broken that threshold, you could not use force to stop him. With the rewriting of this law, a reasonable person would believe that a person trying to break through your door with a machete in their hand is attempting to cause you serious bodily harm, injury, or death, in which case you would be justified for using force to stop them coming into the building. You should still call 911 if you can, but you would not have to wait for them to physically get to you before using force. The change in the law allows you to use force, be that pushing, kicking, shoving, pepper spray, other non-lethal force up until deadly force, any place that you can legally be as long as you're not committing a crime. So that would be your place of work, your home. If you're outside in your front yard cutting the grass, without retreating. So right now in this situation, if you came home and you opened the door, you would have to retreat away from this gentleman before using force if you were able to do so. But that's a real situation that happened, as I said, this week in Kailua.
Todd, just looking through the comments, I see a lot of people that are hung up on this whole you have to let them hurt you first sort of thing. That's not really what this bill is about. I mean, what Andrew is talking about is the current iteration of the law as it stands. The new bill basically is just saying you have a right to defend yourself from someone who is intending to hurt you with bodily harm, as Megan said, with deadly injury, basically a deadly level use of force. If everything fits in your head, and you're looking at a situation from your point of view, and this person is coming at you with a machete, you have the right to pretty much interpret that, with the way their body movements are moving towards you, that they're going to have an intent to harm you. There's just certain parts to it. Somebody's coming at you like this, that means something's probably going to happen. I think a lot of people are getting hung up on this idea that, you have to let them hurt yourself first. That's not necessarily the case, but there has to be clear intent on their part to hurt you. You can't just shoot them because they grab a piece of gum, and run out your store. You can't shoot somebody in the back, because they stole something off your porch. You know what I mean? You cannot engage someone in that way. And that's really kind of what a lot of these questions are kind of keying off of. It's whether or not the person is coming at you to intend to to hurt you, and that's really what this bill is about. We've seen so many examples where people have gotten hurt, because the criminal has intent to hurt them while they're doing the crime. There are some where they're just trying to steal the item. They're not trying to hurt you. And those are the ones that this bill would not apply to. If you shoot somebody in the back as they're running out the store, then you're going to be held responsible for that. So I think there's a lot of questions that have come up actually on that. So
Mike,
oh, sorry, go ahead.
let me just clarify something. So Andrew might be able to answer the second part, but the first part of that is, currently, as the law is written right now, if you believe that it's necessary to protect yourself using forcible force that equals death, you can use that force, even if you're not physically injured yet. So for example, if I'm home by myself, me, 40-year-old something female by myself, and a guy breaks down my door and just yells at me, excuse my language, but I'm going to fucking rape you, and he hasn't physically hurt me yet, I can shoot him because I believe that it's reasonably necessary to protect myself from being raped. He doesn't need to take my clothes off and, physically rape me before I shoot him. If I believe it's reasonably necessary to protect myself from rape or sodomy or serious bodily injury or the other listed offenses in the current statute, then I can. So I want to be clear that that's the status of the law now. I'm not sure how the new law changes that, Andrew.
So the new law still keeps all of that in place. The main thing that it does is adjust where the use of force applies without having to retreat. So in the same situation, if you were walking down a hallway in your office building and the guy said that and you had an opportunity to run away, get into a stairwell and outrun him, that's what you would have to do. In this situation, if the guy is in the hallway and says, I'm going to rape you, you don't have to run away from that situation. You can confront that situation and stop that situation right then and there. You don't have to run away and then try and reach for your weapon or, whatever it is you need to do. It adjusts that. It applies to your vehicle. It applies to your home. It applies to anywhere that you can legally be. Now, with regards to deadly force, Hawaii still doesn't allow people to carry firearms outside of their home. So again, a lot of the common questions we're seeing are with regards to situations like at gas stations and stuff like that. Those situations don't apply in Hawaii right now because we can't carry weapons outside of the home. Now, down the line with lawsuits that are going on with regards to firearms outside of the home, that may become a place that you can legally carry. And then, this law would apply in those situations as well. But the main thing that this law does is adjusts where you can use deadly force to any place that you can legally be. It makes it clear in the situations of when you can use it. So the situations still have to apply. You still have to have that reasonable fear that something is, or that reasonable belief that somebody is going to cause you harm.
Yeah, and I think for this bill, I don't think it changes how you would react in the actual self-defense situation. I think it's more protection after the event occurs, right? As far as being arrested, going through a trial, and being sued. I think that's the key point of this bill. I mean, when you're being attacked, you're going to still do whatever it takes to stop the attack, right?
I think a lot of the changes in the wording of the law are to address and clarify what force can be used when and where. A lot of the rules, a lot of the procedures of when you can use it are still the same. It just clarifies the wording to make sure that victims in this situation have more rights and that the rights are more defined, would be the better way of explaining it. The bill doesn't really change when you can use deadly force. It clarifies when you can use it.
So I have a quick question, Andrew. Can you hear me?
Yeah.
Okay, so under the current regulations, if someone comes on your property and your dogs are outside and they're killing your dogs, since dogs are considered legally property, you can't do anything to stop them under the current law, correct?
That would be correct.
But under the new law, the proposed bill, you'd be able to defend your property and including your animals. Or would you?
So the way the law is changing in that situation, you would refer to the section of the law with regards to the use of deadly force to defend property, which means that you can go ahead and use reasonable force to stop them committing a crime. But because they have a weapon, that then becomes a deadly force situation, in which case you may be qualified to use deadly force. Again, Hawaii's laws with regards to use of force for defense of yourself, defense of others, defense of property is written into multiple sections. And all three of those sections need to be clarified at some point down the line. What they're checking now and what they're clarifying now is use of force in regards to defending your person. So the law in this situation doesn't change the other parts.
All right. Any other questions from Facebook, John?
Todd, I think John had a question about the different tiers. What are the different tiers of force? So I'm going to clarify that. So under the current law, there's no set tiers. The law doesn't say, okay, if someone's using their fist to hurt you, you can use your fist. If someone's using a knife to hurt you, you can use a knife or another weapon to hurt them. If they use a gun, you can use something. I mean, the law doesn't do that. It really is what is reasonably necessary to protect yourself against the equal force that's being brought against you. So it's a factual question that needs to be determined by the fact finder, whether it be a judge or a jury. I will clarify that, because I think people hear police officers' conduct. There's an internal policy within HPD that you do have to use certain levels of force before you can move up to the next level of force. The HPD is required to go through certain steps. And I mean, I'm definitely not an expert on that, but they have different tiers of use of force. So I'm not qualified and I haven't looked at it for a long time, but it escalates based on the suspect's use of force. So there's a difference, right? HPD is required to do that. Citizens are not.
Yeah, just to piggyback off of that, I mean, there's actually a couple people that are asking about the bill specifically, which is how does it affect strangers? And just reading through the bill, like if you're trying to protect your neighbor, you have the right to protect your neighbor as well. As how I can see it says, the use of deadly force is justifiable under this section if the actor believes that the deadly force is necessary to defend oneself, one's legally occupied dwelling or motor vehicle, or another person against a person who intends or endeavors to use unlawful force, or against a person who intends and endeavors to enter the legally occupied dwelling, et cetera, et cetera, et cetera. But I believe that's basically stating that you have the right to defend somebody else who's being attacked, right? Megan, does that sound appropriate?
I can't, sorry, I haven't looked at it. Well, I can't,
okay.
I can't gather. Andrew probably can answer that question.
I just
Yeah,
from my
the way
point
the
of view, it
bill's
does
written-
sound like you can. So
The way the bill is written, that's the way it's written, is that you can use force under that section to defend others.
I think we also need to answer the 2050 thing, because people keep on asking that question.
That's probably the most common question I get out of any bill that we put up on our webpage. Anytime you see a date on a bill that says effective and it says some really obscure date, in this case, I believe it says July 5th, 2050, that's a placeholder date. So once a bill goes through the legislative session, when it gets to the very last hearing, they will amend that to go into effect usually July 8th, so 7 days after the last sign-in date, where the governor has to sign it, or it will go into effect January 1st of the next year. So, for example, this bill will more than likely, if it's passed through the legislature, go into effect immediately, in which case it would go into effect July 8th. And that's the last change that they'll make to the bill. The 2050 date is literally just a placeholder.
I mean, in addition to that, I mean, just to piggyback, just to explain, I mean, Megan is an actual attorney and lawyer. So for her to say something, she really has to make sure that she checks the bill and understands it. I'm not. So, you know, it wouldn't hurt me too badly if I say something wrong. So I totally understand why Megan is hesitant to comment on some of these things. So just to kind of explain that, Megan.
Thanks, Mike.
Yeah, and just to remember that this bill already went through a lot of changes too. It was originally, it actually took away self-defense rights in its original wording. Then when it was in the House PDP committee, they changed it. Was it Ichiyama and Eli are the chairs for that committee? They changed the wording to become what it is now, a full victims' rights, self-defense rights bill. And this was modeled after Representative McDermott's bill, HB711. So they basically got and replaced and just copied the language from 711 to this bill here. Yeah, but I think our time is coming up. Let's have some closing comments. Let's go with Michael first.
When it comes down to it, I mean, the bill is available for you to read yourself. You know, you can read through this bill, and you may not be an attorney or a lawyer, but you can interpret it yourself to see what it means. You know, just take a moment to read the bill, try to understand, go look at the current existing law and see how it's currently stacked up. And I think you can kind of see, I mean, I see clearly that this is basically it's not about guns, like we said. I know there's a lot of focus on that, but it's not. This is just a general self-defense bill that means that you could be walking to your car, you could be in your home, you could be in your workplace, wherever, you basically have a right to defend yourself. And I think history has shown that really, as the general public and our community is concerned, we are kind of on the back foot when it comes to protecting ourselves. You know, we have to run away. So I really can, I think this bill is great. I think it's an improvement in a lot of ways over our current laws. So I really would encourage you to do some research. Don't take our word for it, because again, this is just an advice panel, but go take a moment to go check it out. Now this thing you have to have your testimony in by the 22nd at 2:00, because I believe it's on the 23rd it's being viewed, right? So it's 24 hours. Is that correct? I believe so, right?
Yep, that's correct.
I think it's 20, yeah.
Yeah, written testimony, preferably 24 hours ahead. If you want to talk on Zoom to the committee, that has to be requested at least 24 hours out. Yeah.
So yeah, I mean, so, you know, take a moment, do some research and check it out. And just think about all the different situations we've seen on Stolen Supply where maybe this bill could have helped. I think if the criminal knows that you have a right to defend yourself, then they may be a little bit more hesitant to actually do something. So that's my take on it. Thank you.
Thanks, Mike. Megan?
Thank you, Todd. Thank you for inviting me. I am honored to be here. I haven't seen you guys for a while, so thank you. I will say the status of prosecutions right now is concerning to me. Although I am a defense attorney, I'm still a citizen of Honolulu, born and raised here, in a very different time and circumstance than we see now. I talked to many different people. My CPA on Friday said, you know, I'm scared of guns. I don't like guns, but my wife and I have signed up to get a permit for a gun because we don't feel safe. You know, they're concerned about their safety. So the climate that we're looking at regarding prosecutions is not good for victims. I have many cases that are being pled out or dismissed or not even charged just because of the climate of prosecution here and in the United States. And so I think people need to be a little bit more proactive now about protecting themselves. You know, I know my rights. I know what the law is. I'm very comfortable with using protection if I need to. I would not hesitate to do so. And I think the more knowledge that people have, then the safer they feel with using self-defense as well. So educate yourselves. If you have any questions, I've always said, you're welcome to call me. I'm sorry, this was late. I'm a fill-in for somebody. I got invited to this very last minute, so I am not familiar with the bill. I apologize. My role was to talk about the law, the status of the law now, but if people have specific questions about the bill as it's written from a legal standpoint, I'm happy to answer those questions.
Yeah, thank you, Megan. Yeah, and it was last minute. We wanted to have this webinar just so people can understand the law and testify for or against it on Tuesday. And yeah, thank you very much. Yeah, it was last minute. I think I told her yesterday if she could come down, and she'd be delighted. So thank you very much. Yeah, Andrew.
I mean, thank you, Megan and Michael, for joining us today. I mean, it's not often we get to do these kind of things and actually have an opportunity to make some good change. For the people, as Michael said, do your research, guys. Go take a look at the legislator's website. If you go to the hawaii.gov website, you can click in the top left, type in HB534, look up the wording. You can go to our website, which is hifico.org. That's HIFICO.org. And you can click bills at the top and find the bill from there. It gives you our breakdown of what the bill is. It shows the current status of the bill. It'll tell you when to submit testimony. There's the links to submit testimony if you want to. Go ahead and look at the current self-defense laws. Go ahead and look at this law. As you know, I'm a big proponent of this law purely on the fact that it is a victim's rights law. It changes the law in favor of the victim, rather how most laws in Hawaii seem to be written right now, which is in favor of the criminal. This is about protecting your right to self-defense, which ultimately is a human right. I think, everybody thinks, I can't see any person saying that they don't have the right to defend themselves should the opportunity be presented. Thanks everybody for joining in. We've had a few hundred people watching, taking time out of their day to come and learn and partake in what we're doing. So thank you everybody that's tuned in.
Yeah, and again, thank you for all the panelists. This was very last minute. I think we threw this together 2 days ago because we wanted to get more input on this bill. And yeah, it's very important to think about these things ahead of time, not when the incident actually happens. And yeah, provide your input. But yeah, thank you for everyone for attending.